Turning a 401k, IRA, or retirement savings into a regular income that will last as long as you do is no easy task. The Retirement Roadmap Radio with Mark Fricks can help you possibly achieve this goal and get your financial future in tune. Don't wait. Contact them at 770-980-9262. And listen to Retirement Roadmap Radio with Mark Fricks, Saturday mornings at 8:30 here on AM 920, The Answer.
This is Retirement Roadmap Radio with Mark Fricks of Master Plan Retirement Consultants. Listen in as we address your retirement concerns and provide insight to help put you on the path to achieving your retirement goals. And now, Retirement Roadmap Radio.
Hey folks, welcome back to Retirement Roadmap. My name is Evan with Master Plan Retirement Consultants, and with me as always, Mark Fricks. Mark, how are you today?
Doing great. How about you?
I can't complain.
Good to see you.
Today's topic, one of the biggest concerns for retirement planning is making your money last. Outliving your money is perhaps the greatest risk in retirement. So, what happens if you are successful in maintaining your wealth through retirement? What are the concerns for the future? Leaving a legacy to the next generation is the hope of many. Today we'll be discussing legacy planning and how to not only approach legacy planning successfully, but optimizing your estate for the next generation and beyond. As we've discussed in previous episodes, Mark, legacy planning is a key component to retirement planning.
It really is. It's a piece of the puzzle. You leave that out, you're leaving out some very important aspects. Why work all these years, save, do your best you can, and then let it, when you pass away, let it go to the IRS, let it go to attorneys through probate, let it be maybe wasted by maybe some of the children are a little more spendthrift than others, things like that as well. So it's another part of the maximization of your estate and your legacy and all that you've worked for.
Right. And you know, we've had people come in before too for consultations, or even clients who initially have said that they're not really concerned with leaving to heir. Maybe they don't have any heirs. Maybe they're not so worried about a legacy. And then you start to unravel. Okay, well, what's the alternative? Where would your money go otherwise? Yeah,
I love it when they say, "Well, I don't really care where it goes. We just go," and I'll say, "Well, do you want the IRS to get most of it?" And attorneys, they go, "Oh, no. Well, then." There's somebody somewhere, some organization you love, some foundation that you could leave it to and do a better job with it. So it's always, if you've got any kind of an estate at all, and some of you listening probably are thinking, I don't have anything. Well, you might be surprised what you have when you start adding it up and start maximizing it. And it's not like, most of us are passing away tomorrow. Maybe you got another 10, 20, 30, 40, 50 years to go. Who knows what kind of an estate you're going to have then, especially if they're working with us.
Right, of course. So beginning with legacy planning, what is the first approach? What are the basics?
Well, I was reading in prep for the show that 68% of Americans don't even have a will. Okay, so now that's not necessarily legacy planning, that's a document, but at least start with a will. Even if it's, now don't write it yourself, many times that won't be accepted because a will does have to be approved by the probate court and the probate judge, but you can get a pretty inexpensive will. So if you've got a really small estate and not much going on and things like that, I don't care if you're 25 or 30 years old. We have clients that are that age because they're children or grandchildren of our older clients. I still insist on helping them get a will because you just don't want to leave a mess like that. And it's horrible, but younger people do pass away. So at least the basics of a will. I would also certainly stress the importance of a financial power of attorney, which basically gives somebody else the right or the power to handle your financial affairs if you cannot. And then the third document you really want to have is a healthcare directive. And those last two documents need to be written according to the state you live in. So if you're in Georgia like we are, it needs to be the Georgia Healthcare Directive. And this is where it gets kind of weird too. If you travel a lot, if you full-time RV or you spend half the year in Florida and half the year in Virginia or whatever, you probably want to have those documents for both states. Because if you end up at the hospital and they need to do surgery and your document says Virginia and you're in Florida, it may not work very well. So now you're wrapped up into what we call living probate, which is another problem. And I know this all sounds kind of confusing, but really just 3 basic documents that you want to at least start with. And again, that's not legacy planning, that's having documents, but it's really important. You pass away, it's called intestate, which means without a will. You pass away that way, the court decides where your money goes. Okay, now they have a formula, but it starts with spouse and children, but it can spread out to nieces and nephews and aunts and uncles and people you don't like and all that kind of thing. So go ahead and at least get a very basic will set up.
Now, you did mention with the healthcare directives that they're different in every state, and I'm sure every state has slightly different rules and regulations, slightly to maybe largely different. Say you are RVing everywhere and 50 states, in a year, it's going to be really difficult to get 50 different healthcare directives. Will one state's healthcare directive work in another state's?
Boy, that's probably an attorney question.
Yeah.
Because I've not really run into that totally. Usually we'll have somebody that might travel to a state and things like that, but I've never really asked that. That's something I probably need to do some homework on because I'm not really sure. But that's a great question, a great something to think about. Maybe it would be good enough, or maybe there's a more of a generic form you can use that would help cover more states. Great question. I'll follow up on that.
Well, an in-state healthcare directive is important to keep that up to date as well, because those will expire or they'll get a revised version, and you want your doctor to be familiar with the up-to-date version and not one that maybe they haven't seen yet or aren't used to seeing as frequently.
Well, like the financial power of attorney, I know in Georgia and several of the states surrounding Georgia, the laws about financial powers of attorney changed back in 2017, 18, 19 due to changes in law. So the old forms were of very little value. And so if you've not updated and you're in a state that things have changed, again, I mean, it's a lot of work. I wouldn't say a lot of work. It is work, okay? But it's something you really need to keep up with for sure.
Okay. So we've got those main documents. What about beneficiaries on accounts? Are those affected by those? Are those one and the same?
Yeah, so you want to make sure if you've got an account that has a beneficiary, so that would be an IRA, 401k, an annuity, a life policy, those have places to list a beneficiary. You want to list people, okay? And so those do not go through your will. They don't go through probate. So that's a good thing, okay? Unless you write down to my estate. And then all you've done is shoot it through probate, okay? So make sure you get those filled out. I have found a lot of people that maybe they have a 401k at work that's 20 years old and they never filled out the beneficiaries, or maybe it's an ex-wife or an ex-husband or whatever. So you want to keep those up to date as well. But that's a great point, that those are items that don't go through probate, don't go through a will. So that's a separate item you need to take a look at.
With all of our clients here, we do beneficiary audits pretty regularly. We do, before I go on, I do need to make a disclaimer. We are not attorneys. We are not estate planning attorneys. So any legal documents, anything like that, we cannot write them. We do not advise on that beyond our scope of the financial planning that leads to that. Now, we do have associate attorneys that we work with regularly. What percentage of our clients do we end up creating a will for, or a trust for, or moving into that estate planning?
Maybe 90%,
right?
Or at least make sure they get it done. We always want to make sure they have it done. Whether they use an attorney we recommend or refer, we have 3 or 4 that we can refer, or whether they find their own, we do follow up and make sure we have copies of it as well. And that way we can go back and check, hey, this document's getting old. Have you gotten it updated? Do we need to update it? Things like that. So it is something that we stay on top of, and I think that's a great point.
And a great question to probably ask yourself is, do I know who all my beneficiaries are? A lot of people have tiny 401ks here or there from somewhere they worked 20 years ago, or maybe something they're putting into every week or every month, and maybe they still don't know what their beneficiary is on that account. So that's something really worthwhile to audit your own accounts and see who your beneficiaries are listed as.
Or maybe even where your will is.
Or even where, the people who need to know. Yeah, you can know where the will is, but do the people who need to know once you're gone know where the will is? So that's a little bit about beneficiaries. One of my favorite topics about legacy planning is taxation on the next generation. We do tax planning all the time with our clients. It's a huge factor. A lot of times people don't realize that it's not only taxation for them, but on the next receiving generation. Can you talk a little bit about that?
Yeah, so a couple of things there, and I don't want to get too far in the weeds with this because it can get complicated, but a couple of things to watch out for. Number one, all the money you have in a 401k, an IRA, any kind of a tax-deferred pre-tax account, once it goes to the next generation, they're going to have to get that money out of there within 10 years.
Tax deferred meaning IRAs, 401ks,
SEPs, things like that. And so, here you have kids or nephews or nieces or whatever inheriting these accounts that may have gotten pretty large by this time. And now they have them, and without direction, they can take it all out on day one. So $500,000 coming out on day one, they're taxed at today 36, 37%. Who knows what it'd be in 5 or 10 years from now. So you've got that problem. So some tax planning to go along with, now this is where we get into legacy planning, right? As opposed to just having documents, maybe we need another level of documents to direct some of the distribution of that money, other money. You also have something called a step up in basis, which is where if you've got something that's not in an IRA, but has a lot of profit in it, you want to pass that on correctly, or they're going to owe taxes on what you originally paid for it, not what they inherited it at. So that's another level of planning that's part of the legacy planning.
I want to take a quick moment and remind you guys that masterplanretire.com is our website. You can go there for multiple retirement resources. But most importantly, if you would like to speak to a financial advisor concerning your own retirement, we offer complimentary consultations. You can schedule a meeting with Mark himself, discuss your woes, your joys, your hopes, your dreams for retirement. We can run some reports for you, so take us up on that, masterplanretire.com. Additionally, you can reach us at our home office in Marietta, Georgia, 770-980-9262. As far as taxation on the next generation is concerned, there are some hidden taxes that people don't think about, or maybe not hidden, but gotchas that maybe they're not prepared for. In fact, we discussed something this past weekend. We were teaching in Charleston, South Carolina, a taxes and retirement seminar, and we discussed the step up in basis and found out a couple folks there had actually potential issues with that.
Yeah, they'd already made that mistake. So one of the big mistakes I see people make a lot, and whenever I teach a face-to-face class, as you know, because you're helping me, is that when you talk about this problem, you'll have a couple of people look at each other like, we did that type of thing. So try not to point them out too obviously, but so just a quick little scenario here. Let's say that I'm in my 80s or 90s and I'm slowing down and I'm a little concerned about my memory and how can I take care of my stuff. And so I call up my daughter and I say, hey, I'm going to just go ahead and put my house in your name, okay? And that way, if anything needs done, if I'm incapacitated, you can handle it. We don't have to worry about it going through probate. Sounds like a great plan, okay? A couple of problems. Number one is if you give away something that large, technically you owe an estate tax, okay? Because by putting somebody else's name on something, you just gave it away. Or even if you just put their name on it with yours, you just gave away half of it, okay? So there's that problem there. Number two is if you leave someone something through your will or trust, okay, like my house that I just mentioned, and I paid $200,000 for it, and now it's worth $500,000. I pass away. If my daughter turns around and sells that house the next day, that $300,000 in profit disappears. Her new basis, her new cost involved is $500,000, so she would owe no taxes if she sold my house. Now, if I did what I said earlier, which is say, here, honey, put your name on my house, she would have to go back to the original $200,000 I paid for it, so she would owe taxes on $300,000. So I call that lazy legacy planning or something like that. The intent's good. This is where I see it a lot, is on checking accounts, savings accounts, things like that, where, hey, I'm going to put your name on my checking account, honey. That way you can get to the money if you need to. If I die, it's yours. It's a joint account. Again, you've just given away either all of your account, or if you just add their name, you've given away half your account. Now, you can always make them a signer. That's okay, but a lot of people make them owners. So anything, whether it be stocks, anything that has a title or deed, you want to make sure it goes through legacy planning, not through giving something away, because it's just a tax problem, not only from an estate tax problem, but again, the capital gains and the losing of the step up in basis.
And technically, you owe gift taxes on top of that.
Yeah. Well, and also, let's say I put my daughter's name on my house, she turns around next week and her husband files for divorce. Well, guess what? my house is up for grabs, right? Because she owns half of it, or maybe all of it. Or she gets in a lawsuit, so you've lost control. You feel like you're gaining control, but you actually have lost some control.
So we can't really give a recommendation because this is all hypothetical clients,
Right.
but what are some other options for a home or large accounts? You mentioned a will or a trust.
Yeah. So definitely want to send it through the will. Now, we've not talked about trust yet. And again, as Evan mentioned earlier, we're not attorneys and I'm not recommending anything. We're just discussing the types of documents. But a trust is a higher level of making sure that your stuff's taken care of. Okay, so a will is a set of instructions to a probate judge. Okay. They have to sign off on it, say, yeah, the will is legitimate. You have to advertise it. It's got to be in the newspaper. It's public record, so all your business is out there, so to speak. People can come out of the woodwork. You know, some cousin that never liked you and you never liked them. Hey, he promised me this. It can be contested. So a lot of times, many times, we will discuss maybe doing a trust because a trust is a private document. Think of a trust almost like a corporation or an entity. And so what you do is you create this trust and instead of things being in your name, it's in the name of whatever the trust is called, the Mark Fricks Trust, okay? And so then I changed the title on my house to the Mark Fricks Trust. I can change my bank account, my cars. I can change other accounts to that trust. Well, since it's not in my name, it doesn't go through probate. Okay, so it goes through the trust. And again, no advertising. You don't file the trust with the state or the county. And I can control it more. So with a will, you pretty much have to, hey, you've passed away, you've got so many months to get that stuff through probate and get the money to the beneficiaries. A trust, at least in Georgia, can go for 130 years. So I'm not saying you should do that, by the way, but I'm saying what if you want to spread your money out over 10 or 20 years to save on taxes with the IRA? Maybe you've got some kids that are younger. Maybe you've got a child that maybe has some spendthrift things. Maybe put some special rules around that. Much more control. So it's just a way of, and it can potentially save on estate taxes. Now, we don't have a big problem right now with federal estate taxes, but it's coming back to haunt us, okay? It's fixing to be reset at the end of 2025, and then I think it's going to be further reset in the next 5 or 10 years because guess what? The government needs more money, okay? So that's something else that needs to be part of the legacy planning is do we need to and how do we avoid not only federal taxes, but the possibility of estate taxes too.
What about state estate taxes?
There are some states that also have death taxes, so to speak, and I don't know how many there are. I've never really counted them, but there's quite a few that have that as well.
I know New Jersey is because I have family in New Jersey, so I'm very well aware that.
And I know
New Jersey
Pennsylvania does because
Yeah.
I just had somebody move down from there, and still, even though their mom died here, they had to go back and pay death taxes in Pennsylvania.
Was that because of the checking account? I don't.
It's something to do with the checking account. They used the same bank and moved it down here, but it was opened in
Really?
Pennsylvania. Very strange.
Wow.
Weird stuff out there, and we learn something new every day, by the way. So
Even
that's
with the change of address that did that. That's crazy.
Yep, they came back and got them for
Wow.
it. So, yep.
So a little bit on how we decide whether someone needs a will or a trust. What determines that direction?
Well, part of it is amount of assets. Okay, so generally when people start getting up near the $500,000 mark, I start leaning more toward a trust. Or if you have property in more than one state. Because everywhere you own property, I'm talking about it could be land, a house, it could be rental property, it could be a lot, it could be a timeshare. Okay, if you own property in more than one state, that has to be probated in every state that you own property. A lot of people have timeshares in Florida or maybe in the Caribbean. You want to go have somebody go down and probate in the Caribbean? That's not an easy thing. Florida is one of the more difficult probate states. So now you've got that. So if it's in a trust, what did I say? It doesn't go through probate. So you've avoided that. So there's other reasons, but those are the two big reasons. Privacy. Got a lot of clients that the more money you have, the more private they want to be. But it's kind of triggered with property and the amount of assets and kind of where their assets are. And one other thing to think about as well. So one thing you need to know is that qualified accounts like IRAs, 401ks, IRA stands for what? Individual retirement account. it cannot be put into a trust. A 401k cannot be put into a trust. A Roth cannot, but you can make the beneficiary the trust. And then you pass away, it goes into the trust. Trust says, Bob gets this, Joe gets that, Mary Beth gets this, you don't get anything or whatever, and this is how you get it, and when you get it, and how long you get it, and how long you don't get it. So, again, much more control.
Well, and especially if you have some descendants that need to be taken care of after you're gone, you can put a lot of those directions through your trust, correct?
Special needs trust.
Right.
You have a special needs adult child. Maybe you want your grandchildren to get some stuff, but they can't get it when they're 12 or 4. You leave it in the trust until they're 18 or 21. You can designate it for education. You can designate it for being an entrepreneur or whatever. I mean, you put the rules on it. It's your money, and you control it. And I hate to use this phrase, but we say this a lot. Control from beyond the grave is kind of sometimes what we'll say, but it is true. You've worked a long time, and you want to make sure that the next generation or 2 or 3 can enjoy the fruits of your labor and keep building that legacy.
I think control beyond the grave can sound kind of empowering.
That's one way to look at it.
So as part of our retirement planning, obviously legacy planning is a huge part of that. That comes towards the end of our planning phase. Mm-hmm. Once we've established accounts, organized ourselves, we've gone through all of our money management planning, income planning,
Social Security maximization,
Social Security, all the pension maximization, all that good stuff, insurance needs. Then we're moving into our legacy planning. And as I said previously, all the trust writing and will writing is done by estate planning attorneys that we use regularly. But prior to that, we're doing the legwork on that. We're prepping all the information, and essentially we give them all the information that they would require you to give them. And they organize and create that trust for you. Anything else on that?
No, I think it's good. Again, we're trying to connect it together with everything else going on, as opposed to walking into an attorney's office saying, I want a will, or I want a trust, or whatever. They typically won't even necessarily advise which one you need because they don't necessarily know your entire financial information. Right. So we're able to walk in and share that with the attorney, and the attorney goes, oh, I would go this way. And I said, I think that's a good idea too. And we approach the client with it so that, again, it's all being considered.
And even some of your personal information that's not only financial. We know some of our clients better than some of their doctors do, for better or for worse. I would argue for better. Yeah, we really walk alongside like your personal CFO, as it were. Before we close out, just a couple minutes left, is there anything that people often ask about life insurance for legacy planning? Is there anything you could do in less than a minute?
Probably not. No, real quickly, the life insurance is a good way to leverage additional money going to inheritance, going to loved ones in a tax-free fashion. You can throw $100,000 into a life policy, and if you pass away the next day or in 10 years, there's $500,000 tax-free going. And it can help pay estate taxes. So if it goes through the trust, that's something that can be utilized. So that is part of legacy planning. Is there a need for something like that to be integrated into it?
Great. Folks, thank you again for joining us today. I don't know if you could notice, we started speaking a little faster because we're running out of time. There's a million things we could discuss today on legacy planning, but thank you again for joining us. We appreciate it. Don't forget, masterplanretire.com is our website. You can schedule your complimentary consultations with Mark. Feel free to check us out there. Home office, Marietta, Georgia, 770-980-9262. Come on by, we'll buy you a cup of coffee. Mark?
Or we can meet with you wherever you are in the U.S. Okay, we have the capability using different Zoom and things of that nature. But in the meantime, until we do get to meet with you or see you, remember, plan well and prosper. Take care.
This was Retirement Roadmap Radio with Mark Fricks of Master Plan Retirement Consultants. To schedule a complimentary consultation, go to masterplanretire.com or call 770-980-9262. Thanks for listening, and remember, plan well and prosper.
Thank you for listening to Retirement Roadmap Radio. Don't pay too much for taxes or retire without a sound income plan. For more information, please contact Mark Fricks at Master Plan Retirement Consultants. Call 770-980-9262. 888-980-5262. All matters discussed during the show are for informational purposes only. Each individual situation may vary, and the opinions expressed here may not apply to everyone. Materials presented are believed to be from reliable sources, and no representations can be made as to its accuracy. All ideas and information should be discussed in detail with one of our qualified representatives prior to implementation. Advisory services offered through Master Plan Retirement Consultants, a registered investment advisor in the state of Georgia. Mark Fricks and Master Plan Retirement Consultants are not affiliated with or endorsed by the Social Security Administration or any other government agency.